Very much. Thank you for the invitation. Good afternoon, everyone. I'll try to speak briefly about the different ways speech, and particularly illegal hate speech, is framed in the online world and the way this has evolved. I think that the first discussions on let's say, freedom of expression online were about whether the categories that we used to apply to the offline world, like illegal, legal, hate speech, etc., could be applied to the online world. And in principle, this discussion counted with the important or the authoritative intervention of the Human Rights Council of the United Nations, saying basically freedom of expression is protected both offline and online. In other words, what is illegal offline is illegal online. Here, I mean, we could take a conclusion from that, which is that we don't need to, for example, redefine hate speech. Hate speech is hate speech, no matter if it is disseminated offline or it is disseminated online. Of course, we may say that hate speech may have a different impact in the online world, may spread in a different manner, but this doesn't mean that needs to be defined in a different way. However, states, and let me use this word, many states have panicked with the internet, seeing that they couldn't control the public sphere the way they used to control it, via licenses, let's say regulatory authorities, so on and so forth. So what states have been doing recently is to renationalize the regulation of speech. So speech, regulation of speech, protection of freedom of expression is less universal than ever, if it was universal at some point. States are, let's say, in a way, renationalizing. People talk about the Balkanization of the internet, something that in the Balkans, of course, they don't like it as an expression, but let's say the renationalization of the internet. And what we have seen also is states creating specific legislation to curb speech online based on concepts that do not apply offline. The dissemination of online rumors, specific definitions of hate speech that are much broader, more vague than the definition of hate speech in the offline world. We see that, I mean, we see this kind of legislation being adopted as we speak. Cybercrime laws, cybersecurity laws, etc., particularly also during the COVID times, making it illegal to spread rumors online, etc. So this is one tendency that we clearly see, and in some cases also we see the adoption of extremely radical measures that can only be adopted in the online world, and which have a very huge impact on freedom of expression, which are, for example, internet shutdowns. Based on national security concerns, based on, let's say, many different types of concern. But we are seeing them in many regions of the world. So that's one area we could talk about, the regulation of online speech, and the specific introduction of, or the introduction of specific categories when it comes to the regulation of online speech. This is one territory. Another territory would be the regulation of online platforms. Online platforms, intermediaries, have become gatekeepers, have become major players, so that states have seen that they need to be regulated one way or another. The first debates that we saw in this field, and we saw them in the United States, Section 230 of the Communications Decency Act, in the European Union, e-commerce directive, were about liability. Are platforms liable? Do they have responsibility if they host illegal content? And here, there was some tension, particularly in Europe. If you moderate content, you have more chances to become liable. That was a little bit the conundrum of the e-commerce directive, the active versus the passive role of platforms. Section 230 in the United States is more straightforward. It says platforms are not liable for keeping up content, or even if they take down content in good faith based on their content moderation policies, they are not liable either. So in a way, content moderation was, let's say, let's say, promoted in the United States. Now with the Digital Services Act, this has changed. The Digital Services Act is kind of providing some stimuli for platforms to moderate content. Not only stimuli, but also obligations. In the Digital Services Act, now platforms are supposed to moderate content beyond the law. Beyond the law, we'll talk about that. But platforms are supposed to moderate content. And even what is new, perhaps, when it comes to the Digital Services Act, is the fact that beyond these obligations, also platforms are granted obligations that they didn't have in the past, at least from a legal point of view. Procedural obligations to protect users. Transparency, giving users appeal mechanisms, giving users reporting mechanisms, the obligation to provide a statement of reasons, the existence of alternative dispute resolution mechanisms like the oversight board. Now they are covered by a law. This is quite unique in the world, quite special, and this makes the Digital Services Act a very interesting norm. The Digital Services Act doesn't do anything when it comes to defining what is legal, what is illegal. The Digital Services Act defines how platforms moderate content on the basis of categories, illegal, legal, that are established in all the pieces of legislation. But there are also, when it comes to platform regulation, for example, and particularly in Europe, legal provisions that also impose on platforms certain obligations on how to handle illegal content. For example, the Audiovisual Media Services Directive. For example, the regulation on terrorist content online. For example, the Copyright Directive, and more. So there's also this component that the European Union is saying, well, when facing illegal content, you need to do certain things. For example, in the regulation on terrorist content online, if you detect terrorist content, you do not only need to take it down, but you need to take all the possible measures to make sure that it doesn't go up again, which is something relevant in terms of obligations for platforms. So, and there, in this context, also we have the NetzDG in Germany, and also other rules, other norms, other pieces of legislation that go beyond that. The online harms proposal, until in the UK, until recently, was telling platforms, you do not only have the obligation of taking care of illegal content that is posted on your platform, but you also need to deal with legal but harmful content. So you have now the legal obligation to take care of content that is not illegal, but we don't like it. Which is a very strange, from a legal point of view, a very strange and controversial formulation, and particularly if we look at it through the lenses of the right to freedom of expression. So, how is speech framed online? I see three layers. The first layer is international human rights. International human rights law, of course, define freedom of expression and the general limits to freedom of expression. International human rights law particularly applies to states. That's true. Even though in my work, quite often I find that states tend to ignore the existence of international human rights law. And by the way of the discussions we had this morning, I mean, something that I experience quite often in certain parts of the world is like, listen, I mean, you're talking about something that was invented in the contents of the Enlightenment, of a certain relationship between the individual and the state. This is something for the North. I mean, you are here coming with all these, legal standards that don't really fit in our communitarian society where we have different values, etc. Well, that's a struggle. Well, that's a struggle, and I cannot dwell into this, but this is, of course, a very important topic, how to incorporate, even if, for example, in the African system, you have already African instruments, very well developed African instruments, but still assuming human rights and something that states have committed to, nothing imposed from the outside, but something that you have really committed to, is still a struggle. But also now, and this is the new thing, platforms also commit to respect human rights. Something that I might also say, perhaps at this point, is that In my career, I never met a Minister of Information in any country that says that they don't respect freedom of expression. They all respect freedom of expression. They say, in this country, we believe in freedom of expression, we respect freedom of expression. I still even remember that when I was at the OSCE, the Russian ambassador used to start all his interventions in this field with this. In Russia, we have freedom of expression, we respect freedom of expression. The same way that most platforms, they also commit to freedom, human rights as the basic standards. But when it comes to platforms, it's important to note here that, for example, the UN Rapporteur on Freedom of Expression has made reports saying platforms need to respect freedom of expression as enshrined in international human rights law. Of course, this has complexity because, I mean, for example, if we look into the idea of legitimacy, there are limits to freedom of expression that might be legitimate within the context of a state, and there are other limits to freedom of expression that might be legitimate within the context of a platform, but not necessarily within the context of a state. So, I mean, it's not that easy to incorporate human rights into the platforms, but it's true that, for example, we have seen before me the example of the Oversight Board. I dedicated some time, if I may, some self-promotion to write a paper on this matter, on how the Oversight Board looks into let's say, into human rights in the context of content moderation. And I can say that my conclusion is that the decisions of the Oversight Board sometimes are more elaborated than the decisions that we see at the level of international courts, truth to be said. No? So the degree of sophistication, perhaps, I mean, at some point when you have more and more work, you may have to be a little bit more brief. But so far, I mean, this is very elaborated. But even EU legislation, if we look into the Audiovisual Media Services Directive, the Regulation on Terrorist Content Online, the DSA, the EU legislation say when moderating content, platforms need to take into account human rights. What that means, we still don't know, again, because this is something that is very nice to be formulated, but then in practice, I mean, when it comes to the applying, let's say, these to specific examples, I think it will be challenging. But the truth is that we see consensus in legal instruments when it comes to the importance of human rights. Then we find, of course, talking about how speech is framed, we find national instruments. I already talked about the laws that frame speech, the laws that impose certain obligations on platforms, but we also see now more sophisticated interventions from states that should raise concern. For example, state addressing a platform and saying, look, this piece of content, I'm not saying it's illegal, but it violates your terms of service. Is that a state request? It should be treated as a state request, or it's something else. Because, of course, for a platform, it's different to receive a complaint from a user saying this is a violation of terms of service, or, let's say, to receive, I'd say, from the police, of the anti-terrorist unit of the police, a notification saying we believe that that should be taken down, not because it's necessarily illegal, but we believe that it violates your terms of service. That's something interesting. The Oversight Board recently issued a decision on this matter, which I think is very interesting. And then also you have these discussions about prominence regulations. Can states impose on platforms the obligation to give prominence to certain types of speech? Can state regulation impose mass carrier rules on platforms? For example, say, I mean, certain types of content, you cannot take them down. You need to give prominence to, I don't know, public service broadcasters, to traditional media, vis-a-vis other types of users. These are discussions that now we are having with some sort of a soft intervention of states on platforms, but it's relevant. I think that, and we need to contemplate it in our discussions. And the third and most important layer here, probably, are the rules that platforms themselves establish. Because these rules go beyond the law. There's these differentiation between what is illegal and all these things that populate platforms that are not illegal, but probably users don't like them. And platforms are deciding on these pieces of content, are saying what is, for example, nudity. There is something that is legal, but we don't want it here. And these type of decisions to define what users deserve to see beyond what is legal is something that is still in the hands of platforms. This is based on their own values, on their own interpretation of human rights, probably. Also, platforms usually try to find, let's say, some sort of a common legal denominator to kind of not to get in trouble in different jurisdictions. So let's ban, for example, let's ban hate speech or the denial of the Holocaust. We know that that is legal in some countries, but it doesn't make sense to say, okay, we geolocalize and this is acceptable here, not acceptable there. Let's create a common denominator and we avoid problems. That is something that affects, let's say, quite a lot the way platforms decide on the content. And the very last element here is users. We users have a certain influence because at the end of the day, of course, what we see in our timeline is connected to what we have chosen in the past, is connected to the people we follow. So we play a certain role, but now is the discussion, we have the discussion on how to empower users, how to give more power to users to decide what kind of content moderation policies they want to be subject to, and the kind of values that need to be defended, let's say, in the context of an online platform. And here you have the discussions about interoperability. And we discussed that in New York a few months ago, also with Justitia. That is really complicated. Can we interconnect platforms so that the user can choose the type of content moderation policies? This triggers technical problems, problems at the level of privacy, for example, etc., etc. But I think that the future discussions on these matters will be about exactly this, how to empower users. First, because it's good. I think it's good to empower users when it comes to deciding what they want to see. But second, because I think that the model of unilateral content moderation, it's quite unsustainable. I mean, Monica Bickert, she has expressed her frustration. This is something that platforms don't want to do, but they feel forced to do. So some alternative needs to be found because it's frustrating for everyone, and in some cases, it's not good for their reputation. In any case, I mean, this is a conversation that we still need to have. We saw the emergence of Mastodon, for example, which is a model where the users are empowered now that Twitter was in this, I mean, special situation, but we still, many things still need to be discussed in this field to change the paradigm from, let's say, this unilateral content moderation to something that is more participative, etc. So, but I mean, the conclusion also is that we see that we have many layers of influence when it comes to framing speech online. It's not only one type of norm, it's not only one type of intervention, it's not only one type of actor. Here we see many different actors playing many different roles at many different levels. So this is why this is such a fascinating topic, I believe. So thank you very much.
Can I just ask you? Can I just ask just one thing? It's very interesting, really. It is. It's you mentioned the Digital Services Act.
Yes.
And we don't know yet what it will mean and the consequences. You're critical, obviously, but what are the dangers you see just now?
No, I mean, I think that the Digital Services Act has many positive things. Is perhaps the most sophisticated law on content moderation that we have seen anywhere in the world. It's a law that protects users in a way that they are not protected anywhere else. But at the same time, first, it imposes obligations on platforms to the extent that it's hard to believe that it is possible to fulfill all of them. Because, for example, platforms need to give a statement of reasons every time, not only every time that they take down a piece of content, but every time they take a decision on, for example, demoting a piece of content. Every single time. Is that possible? Is that feasible? Does it make sense? That's one concern. That's the first thing, that it entails it imposes many bureaucratic obligations on platforms. And at the end of the day, this may create an entry barrier. Because, of course, if you want to operate in Europe, you need to, let's say, fulfill many requirements. The other thing is that there are very vague obligations for platforms to make risk assessments, to articulate mitigation measures when it comes to the risks that generate, that may trigger, let's say, the limitation of speech that is legal, but is, let's say, but is seen as harmful in a certain manner. And platforms may feel the pressure of limiting certain types of speech, because at the end of the day, if you don't fulfill these obligations, then you have the European Commission regulating you and having the capacity to impose, let's say, very high fines. So the risk of over-removal or the imposition of excessive restriction on freedom of expression is there. Let's see, I mean, still it is not in force. I mean, it will be, I mean, by the end of next year, and we will see what happens. It's there. But also in the pipeline, we also have other rules that will complement, other laws that will complement the Digital Services Act that might be more problematic. For example, the Media Freedom Act that contains certain provisions, the regulation on political advertising. So let's say that the EU now is in some sort of a legislative spree before, let's say, the end of this mandate when it comes to platform regulation, and still we have plenty to be seen.
Just one quick thing. How is this being looked upon in the States? What is the discussion in the States right now about?
Well, in the States, I see more concern than in Europe when it comes to these European types of legislation.
Of course, and yeah, that would be the normal reaction. Is it moving? Is it?
The other thing is that platforms see, these American platforms, of course, they see also, on the other hand, if you wish, they see this as a way to gain legitimacy, in the sense that, look, now we are subjected to all these rules, no, in Europe. Now we will fulfill all these rules that are very complex, very complicated. So now, next time I take a decision you don't like, well, it's not my fault. Yeah. So for platforms, in a way, that is good, in the sense that it gives them legitimacy, and on the other hand, I think that it prevents competition, because it's going to be very hard for a competitor to enter the market if they have to fulfill.
But there is still the same skepticism in the States. It's the same. It hasn't changed.
The question is that now the states are also, I mean, trying to change things. We see the laws in Texas, the laws in Florida, the attempts to change Section 230. So also, I mean, there are things moving in the states to incorporate or to adopt legislation that might incorporate some of the things that we see in the DSA. Right. But it's still very early to tell. But things are moving in the states as well, and we're also expecting some interesting decisions from the Supreme Court on cases that relate to platform liability, which may change a little bit the way we look into it, particularly from the traditional vision of Section 230.
Right. Thank you very much.